Choosing a state in which you should incorporate. Today, our guest, Keith Bishop, recently retired at Allen Matkins after nearly 20 years. He's a former California Commissioner of Corporations. He's run the popular California Corporate and Securities Law blog forever, and he's the author of the first treatise on corporate law for the state of Nevada, which is currently entitled Bishop and Zucker on Nevada Corporations. We're going to talk about the emergence of Nevada in particular as it compares to Delaware law and California law today on realtransparentdisclosure.com. So I'm here today with Keith. Keith is in the Nevada Supreme Court Law Library, which I find fascinating since we're going to be talking about Nevada law, but he's not doing that on purpose because he's writing a book, and we'll talk about that at the end of this video. But Keith, you're always up to such interesting things. You're really one of the most interesting lawyers I've come across paths with. Your background's so interesting. Of course, you're a fellow blogger. I was trying to figure out how long you've been blogging, and you're on a little bit of a hiatus right now, but it's got to be at least 15 years, right?
Well, I started in 2010.
Oh, wow. Okay.
Yeah,
So it is 15 years. I got it on the
years. Yeah.
nail on the head. So let's talk about what's going on with state law because you are the state law expert and things are changing so fast. Can you talk a little bit about the recent changes to the Nevada law and what's going on there?
Sure. Yeah. The Nevada legislature, which is right next door to me today, it meets every other year for 120 days, and it meets an odd number of years. So this being 2025, it met this year. The session ended at the end of June, and they passed AB 239, which is a fairly lengthy business entities bill. And so they're definitely trying to, continue their competition with Delaware. The bill, I can talk about three or four things that the bill did. It does a lot of other things, but one of the first things that the bill did is it allows Nevada corporations through a charter amendment to provide for bench trials for basically internal actions. Nevada, unlike Delaware, you have a jury trial. The courts generally provide for jury trials. So one of the selling points for Delaware has always been the competency experience of the Court of Chancery and no jury trials. So Nevada has been at a disadvantage in terms of the ability to get out of having a jury trial, and now corporations can elect to get out of jury trials for internal actions. Internal actions basically will include derivative actions and actions involving breach of fiduciary duty by directors or officers, or actions to interpret or enforce or contesting the validity of the articles or bylaws. This is really a first step in a bigger move, which is going to take some years. In Nevada, judges are elected, including the Supreme Court. They do have a business court division in Northern Nevada and Southern Nevada, but these are elected judges. Delaware, of course, appointed judges, chancellors and vice chancellors. So there's a move to have an appointed business court in Nevada, which would require a constitutional amendment. And that process is a lengthy process in Nevada. It can't be done in just one legislative 2-year cycle. Recently, the Nevada Supreme Court, the Chief Justice of the Nevada Supreme Court, asked the Supreme Court to create a commission to study the issue. But I think that Nevada is definitely moving in that way. So the first thing is bench trials are going to be available in certain cases for Nevada corporations. The second thing legislative change addresses controlling stockholder liability, which has been a big issue, as you probably know, Brock, in Delaware. And Nevada's taking a big step in limiting the liability of controlling stockholders. Basically, they now, by statute, say that the only fiduciary duty that a controlling stockholder owes is to refrain from having undue influence over a director or officer with the purpose and proximate um, effect of inducing a breach of fiduciary duty that results in liability and involves a contract or transaction in which the controlling stockholder has a non-speculative financial material interest, and that results in material non-speculative and non-ratable harm, or I'm sorry, not harm, but benefit to the controller. Um, and it's important here that the statute would also defines controller as somebody who has the ability to elect at least a majority of the board. So this, I think, is a direct response to all the litigation in Delaware involving controllers and the standards to be applied to controller transactions. It's basically saying that in Nevada, we're going in a different direction with this, and it's going to be a statutory direction. Somewhat related to the controller limitation of controller liability is Nevada is allowing cleansing of controller transactions by a vote of a disinterested committee or by a board upon the recommendation of a disinterested committee. So again, kind of going at all this uh, uh, controversy in Delaware about controller transactions. And then finally, directors, this basically is following Delaware. As you may know, in the Blizzard transaction, there's basically the ruling was that the board had to approve the final documents, which as a practical matter is often difficult as people are trying to hit a moving target. So Nevada basically is amended its corporate law to allow directors to approve non-final documents.
So someone who has written a treatise on Nevada law and has been out there over 30 years, this is huge stuff, right? In the 30 years, this is the biggest changes that you've seen made to Nevada law.
These are very big changes. I mean, it's something that did start. I think I date it to basically the early 1990s when Nevada made its first moves of trying to attack corporations. So it's a process, but these are big, very big changes for Nevada.
So before I ask you my next question, I thought I should mention some stats that I recently blogged about that I got from ISS. And ISS blogged about the state of reincorporations. And so right now, apparently, in the universe of ISS companies that they cover, 63% of those companies are incorporated in Delaware. We have 5% in Nevada. Interestingly, 2% in California. I always felt like California had more than that. But I mean, Nevada's 5%. That's a lot, but still Delaware was 63 is a whole lot. Although, if I didn't know these stats, my guess would have been around 80%, not really paying attention to this kind of thing. And Maryland is number two at 7%. And I think a lot of that is the REIT laws that they have, although Lockheed Corporation, I think, is still a Maryland corporation. I used to work there, but it's been a long time. So for existing public companies incorporated in Delaware, might these new changes to Nevada law be enough, you think, to entice some of them to reincorporate? I mean, a few already have, but it's really
There've been
just few.
quite a few notable examples like Dropbox and TripAdvisor that have, had proposals to reincorporate. More recently, Liberty Live, it's not a reincorporation as I understand it, but a split off it was to Nevada. So I think I think there's a great deal of frustration with some of the recent decisions coming out of Delaware. The high degree of knowledge and experience is definitely a plus in the Delaware courts, but it also leads to a lack of transparency and certainty in results. And so Nevada, by proceeding statutorily and making these changes, is really on a different path than it's basically saying we're going to put these things in statute. You can read the statute and know the rules and have some certainty as to what the outcome will be based on those statutes. Whereas Delaware has historically, until recently, proceeded, through judicial decisions. I always like to say you can read the Delaware General Corporation Law front to back, and at the end of that exercise, know very little about Delaware corporate law. You really have to read a lot of Delaware court decisions and pay attention to a lot of nuance. It's sophisticated, but the sophistication is also the enemy of accessibility in many respects.
Do you think a lot of companies will wait until the Constitution for Nevada is amended and that there is some development of a business court in Nevada?
Well, as I said, there is a business court division now. And with this recent change, they'll be able to amend their articles to waive a jury trial. So I think that's a big plus. What's on the horizon in the future will be appointed judges as opposed to elected judges, if that comes to pass, which will require a constitutional amendment in Nevada. I think there's also, the old saying used to be nobody ever got fired for buying IBM if you were like purchasing computers. I think the same was true of Delaware. Nobody ever got fired for recommending that you incorporate in Delaware. I think that's changing as you see these notable companies that don't have a particular physical connection to the state of Nevada, converting to Nevada corporations. And then you're seeing business leaders basically endorsing Nevada. Whatever you may think of those business leaders, it's making it okay to choose Nevada as a state of incorporation. Whereas before, I think everybody was concerned about being a first mover, and so the easier thing was to just incorporate in Delaware. Nobody would ever criticize you for that choice. Now, I think it's okay to look at other states, Texas and Nevada in particular.
And what about startups, like if or even forming an LLC? Do you think that they should initially incorporate in Nevada and then figure out later if they're going to be able to go public that maybe they could reincorporate as part of that process?
Well, the statistic that I've seen is that last year there were 225 IPOs in the US, and that 80% of them were in Delaware. So Delaware's doing pretty good. But recently you may have seen Mark Andreessen came out and said, choosing Nevada was a no-brainer. Again, that's an example of, somebody who's kind of an opinion leader or a successful person saying it's okay to be in Nevada. One of the things that I've noted in looking at proxy statements for conversions to Nevada is they always cite the cost. Delaware can be a very expensive state in terms of franchise taxes, and Nevada's much less expensive by, in some cases, $100,000 or more. And over a period of years, that adds up, obviously. For startups, when you have people like VC leaders saying it's okay to be in Nevada, that's a big a signal that you don't have to be a Delaware corporation to attract VC funding and to attract investors. You can start in Nevada. You can save money. You don't have to worry about a conversion at some later date. So I think definitely can make sense now for startup, particularly in the VC world, looking for VC financing, to say it's okay. You're also seeing law firms that have more experience with Nevada corporations. Before, I think a lot of law firms, particularly ones not in Nevada, that were doing these IPO situations didn't have any familiarity with Nevada law, and therefore were not comfortable recommending it to their clients. Now they're sort of being forced because they're writing proxy statements with long sections of comparing Nevada and Delaware law, and they're really getting into the weeds of Nevada corporate law.
Yeah, the firm I'm affiliated with, Cooley, is obviously number one with venture capital, and so we're very well versed in about law and talking to clients all the time about the choices that they have. So let's go ahead and talk about what you're doing in this law library. You've already written a treatise, the Bishop and Zucker on Nevada corporations, and now you're retired. And as part of your retirement, you're writing another book. And you want to talk to that?
Sure. I'm writing a book on the California financing law, which is a law basically if you're not a bank and you're not a real estate broker and you're making loans, whether they're secured, unsecured, secured by real estate or personal property, whatever, if you're doing that in California, you need a license. And so there are many thousands of licensees under this law that currently when I was in practice, I was always getting questions from um, people who considered themselves lenders to people who thought they weren't lenders, but suddenly discovered that under this law, maybe they were required to have a license. And that included things like private equity funds and hedge funds and just regular companies that thought they were making widgets, but under the law, they may also be engaged in the business of lending money. So since I always was always fielding questions about that law, in my retirement, I'm writing a book. I'm up to chapter 5. I hope to have it finished sometime this fall.
That's so awesome. You're an amazing human being, and thank you for doing that, putting that knowledge to paper, because otherwise we would lose it. Thanks. And thank you so much, Keith, for doing this. Great
Good to
stuff.
see you again, Brock.